What unfolded in the Delhi High Court today wasn't just a ruling on recusal. It was a judge responding point by point to being put on trial herself. Justice Swarana Kanta Sharma made it clear today at the very outset that this wasn't about deciding a complex legal issue, but about deciding whether she should step aside at all. She said her first instinct was to recuse herself without hearing the matter, but she chose not to in the interest of fairness. Because, as she put it, once a judge's reputation is questioned, leaving it unanswered makes it almost impossible to recover. The court noted that while Arvind Kejriwal claimed he did not doubt her integrity, his arguments reflected contradictory positions. At one point, she observed that she was not judging the litigant's case, but the litigant had effectively put her and the institution on trial. On allegations of bias, she pushed back directly. She pointed out that interim orders had been passed in favor of Kejriwal and other AAP leaders at early stages without hearing the other side, and yet no allegations of bias were raised against them. She also addressed the argument about her attending events of the Adhivakta Parishad, saying how can it be assumed that merely attending a lawyer's event means her mind is closed and she cannot decide cases fairly. She added that courts routinely participate in events across NLUs, colleges and legal forums. On the issue of her children being empaneled with the government, the court said that there was no nexus shown with the present case and no material to suggest any misuse of her position as a judge. She warned that allowing such allegations would open the floodgates, where litigants could plant seeds of distrust against judges without any concrete material. She also said judicial proceedings are decided on the basis of record, not on what is said on social media, and that a lie, even if repeated 1,000 times, does not become the truth. On the argument that justice must also be seen to be done, she raised a direct question. Who decides that perception? A dissatisfied litigant cannot be the yardstick for judging a court's neutrality. She also addressed the larger consequence, saying if such grounds are accepted, courts may not be able to hear any matter involving the Union of India at all. And in what she described as a catch-22 situation, she said the litigant had created a scenario where either outcome, recusal or refusal, would be used to suit his narrative. In her own words, when a litigant judges a judge, there cannot be a different standard, and no litigant can sit in the judgment over a judge without evidence. You're watching LiveLaw, and if you want to access a detailed report of today's hearings and more, visit livelaw.in.